he's been incarcerated. And I believe he could probably give you some explanation as to what he's doing and the classes he's in, and those sort of things. Thank you.
Thank you. Mr. Burkhardt, anything that you wanted to say today?
No, sir. I know that these guidelines are going to go concurrent with my current sentence that I'm in, and I would like to apologize because I didn't think anything would come back on the appeal on my guidelines, because I kind of feel like the court's time is kind of getting wasted because everything's getting ran concurrent. But I'd like to say I appreciate you guys, letting me come back and fix my PRV, because I still got 3.5 years on this sentence. So that sentence that I got sentenced with you guys in Otsego County would have been already, done.
Okay. All right. Thank you. First of all, I did have a chance to go through the pre-sentence report again with the updated sentencing guideline information. As I think counsel have indicated, the court is free to adjust its sentence today. But I think, as Mr. Burkhardt's also acknowledged, the sentence in this case through Otsego County really was going to be served before his earliest out date anyway. So as a practical matter, it doesn't have an effect. I do think it's important, Mr. Burkhardt, that your guidelines are scored correctly, and so I don't view it as a waste of time at all. If there were errors, there were errors in that, and the Court of Appeals found that there were errors, and everything needs to be accurate, and it's worth the time to make sure that it is accurate. So,
thank you, Your Honor.
Yeah, all of that to say that I think the original sentence was appropriate, and the change to the PRV value doesn't change the court's view of what the sentence should have been. So the court is going to go with its original sentence, which was 18 months, that to be served concurrent to your current sentence. Mr. DeLeo, did you have a chance to read? We know what his credit is. I know he wasn't entitled to credit coming into it, but obviously since
I don't, Your Honor, I'm not sure that we even. I don't know if we got notice of this. I don't have a file.
Oh, okay.
I can try to figure it out if we have a.
Yeah, if you could just do that at some point. You don't have to do it right this minute, but in the next day or two, if you could provide that to the court just through an email and to Susie at the clerk's office, so that we can prepare a judgment sentence that reflects the accurate amount of credit as of today's date from the time of sentencing. Mr. Roll, anything further that we need to address on this file today?
Thank you, Judge.
Mr. Gilo?
Nothing further, Your Honor. Thank you.
All right, thank you, Mr. Burkhardt. That's all for today, and good luck to you going forward.
And thank you guys. You have a good day.
All right, our next hearing is set for 11 o'clock. We'll be in recess until that time. We're on the record today in People versus Roger Sundek. This is case number 236504. And counsel for your appearance.
For the record, John, am I going back to people?
And for the record, Your Honor, I'm Shannon Smith on behalf of Roger Sundek, who is seated to my right.
Okay. The date and time set for a final status conference in this case. We do have a trial date set to begin on June 24th. So as the final status conference, this is also the plea cutoff. So Ms. Smith, are we ready to go forward to trial in this case, or how does your client want to proceed?
We are ready to go forward to trial. There's just a couple of little tiny issues. First, the defense has some materials that are possible impeachment exhibits. I need to give a copy to Mr. Rolla, but under the child protection law, I'm not allowed to give him copies unless you sign an order allowing me to. So we've stipulated to an order, and I'm wondering if I can present that to the court just so I can send him the materials.
Yep, you want to hand that to the officer?
Yes, thank you. And then I let Mr. Rolla know, we filed our witness list, but we have 2 witnesses. I'm gonna amend it and add those 2 witnesses on today. I'm gonna email him those 2 witnesses' information. And finally, on our jury instructions and verdict form, there are some counts where it's ambiguous as to what the basis of the charge is going to be. So Mr. Rolla and I agree, we know the basis for the charges on counts 1 and 2 and 10 and 11, but counts 3 through 8, we're gonna have to sort out as trial goes on.
Okay.
So we just want to make the court aware, and that's why in the instructions, it's noted that way, and they're not complete, like normally, like, you know, like to
Sure.
have them complete.
Yeah, and that, I mean, that makes sense. That might be something that we need to address after the close of proofs, when we prepare the final instructions.
And Your Honor, that's all from the defense.
Mr. Rolla.
And Judge, that's the latter, correct. So the proofs would then, instructions would comply with the proofs. As the offense of CSC2 can involve touching in various areas. It's anticipated there may be testimony regarding touching in various areas, and then proofs have to comply, the instructions have to comply with the proofs, which is why we also have the additional instruction that the jury may have heard testimony about matters for which the defendant is not on trial. So there may be more touching than is actually charged and was found over on. And that's why we left that open, so that way they can be corrected in the final instructions.
Okay. And Mr. Rolla, you've already submitted your proposed instructions. Ms. Smith, to the extent that you have an objection to any of the preliminary instructions or initial instructions.
No, not to the preliminary or initial, and
Okay.
obviously the envelope to.
Sure.
I did submit instructions also to the court, and I sent them in a Word format and a PDF in case the court needed anything cut and pasted out.
Okay. All right. Mr. Rolla, on behalf of the people, are there any other issues that we're going to need to address prior to trial?
No, Your Honor, not that people are.
Your Honor, the only other thing I would ask that we place on the record is that there has been that Mr. Sundek has not been made any plea offers he wishes to take or consider at this time, just to make sure that we have a clear record, that we've had discussions about the possibility of a plea. I've spoken to Mr. Rolla about it. There have been no plea offers that Mr. Sundek was interested in accepting. I just want to make sure that that's clear with him on the record, making that clear.
And Judge, I can clarify that there were plea offers for counts 3 and 4 with an added count 12. CSC first person under 13, but without the 25-year mandatory minimum for dismissal of counts 1, 2, 5, 6, 7, 8, 9, and 10. And that offer was rejected.
That's correct, Your Honor.
All right, Mr. Sundek, have you had an opportunity to speak with your attorney, Ms. Smith, about those plea offers?
Yes, Your Honor.
Okay. And you understand that the court set today as a final status conference and plea cutoff, which means that today would be the last day that the court would accept any pleas to any lesser charges.
Yes, Your Honor.
And it's still your desire to proceed to trial in this case.
Yes, Your Honor.
All right. then I think we're ready to go. I'll just ask council, the courtroom will be open by 8:15. Mr. Sundek, it's important that you're here, but no later than 8:30 on the morning of trial. It's also important, of course, that you continue to communicate with your attorney so that you're prepared to go forward on that day. Otherwise, the court will be ready to go at 8:30 with the jury. We'll begin with jury selection. I think Ms. Smith, you've tried cases here before, so you know how we proceed.
Yes.
And we'll go right from, once we have a jury selected, we'll go right into openings. That's all I have for today. Thank you.
Your Honor, I do have one really quick question. Oh, my question is very simple. We're the first trial up, right? We're your,
There are no trials stacked with this case.
Okay,
so
perfect.
this trial will go.
I just wanted to make sure. Thank you.
Yep.
Thanks.
Thank you.
I'm here on the route piece also, just so you guys know.
I don't see our 11:15 present yet, so we'll take a short recess until that. We're on the record in People versus Palaski, case number 246716. If I can have counsel put your appearances on, please.
For the record, John, I'd like to roll the people.
Good morning, Judge. John Stafford on behalf of Ms. Palaski, who's here beside me today.
This is set for a status scheduling conference in this case today. Mr. Steffi, can you tell me where things are at with this file?
Yes, I can, Judge. Thank you. This is our first status conference in front of your honor after the preliminary examination was waived. This is a reckless driving causing death case. As such, there is a lot of discovery. I believe there's a lot of discovery outstanding. I reached out with sort of a list of sorts of things to Mr. Rolla at the end of the week last week. So at this time, I would suggest or propose a status conference perhaps next month to see where we're at getting the discovery before we're making a decision about a plea versus a trial date.
Okay. Do you think that you can have that within 30 days? I just want to avoid, setting unnecessary hearings. So
It
I'd
might
rather
take-
set it out if we.
I think it might take longer than that, frankly, just
Okay.
because I think it's a lot.
All right.
Thank you.
Mr. Rolla, would you have any objection to setting the next date at 60 days out?
No, Judge, and I would indicate for the record, we received a supplemental discovery request last Friday afternoon at about 4:35, give or take. I responded to much of that, and I also advised defense counsel that I had forwarded the request to the investigating officers so they can provide information. It'll probably take at least 30 days to get.
Okay. All right. So we'll set this for a status conference in 60 days. At that point, the court's unlikely to adjourn matter out further without some kind of showing of good cause. At that point, I think 60 days should be an adequate period of time for the parties to exchange information and for Ms. Pulaski to consider any plea offers that are available. So we'll send out that notice of hearing. Ms. Pulaski. It's just important that you need to stay in touch with your attorney so that you're prepared to go forward at that time, okay?
Sure.
Mr. Rolla, anything else we need to address for the record on this file today?
Not from the people, thank you.
Mr. Steph?
Nothing, Judge, but thanks.
Okay, thank you. If you want to let Ms. Smith know, both her client and the prosecutor on route available so we can get started.
Yes, sir.
Well, you didn't mention that. I thought that's kind of.
No, I didn't see it. Sorry. I wasn't trying to say.
Christie said they late on the
It's
Friday.
the end of my day.
Mr. Rao, are you able to hear me okay?
Yes.
Okay, we're getting the attorneys ready. It's just going to be a minute before we start your hearing. And Mr. Fenn, we're just waiting for Ms. Smith to come in the room. She is here, so it might just be a minute or two. That's okay. I mean, we're early. Are you ready to go, or do you need?
I am always ready. Yes. I just need to get the right folder out.
Sure.
Yes.
We will go on the record in versus David Rao, case number 236629 and 6630. The record should reflect that Mr. Rao is present by video for the Michigan Department of Corrections. We do have Ms. Smith present here in the courtroom today, and Fenton, who's handling these files on behalf of people, is present by Zoom as well.
Appreciate that, Judge. Thank you.
Sure. A couple different matters we have set for hearing today. Number one is status conferences in each of these files, but Ms. Smith, you filed an objection to people's proposed admission of certain evidence. I did have a chance to review and read your brief on that. Mr. Fenton, I don't know. I mean, I know you guys obviously filed the initial, disclosure of your intent to offer that evidence. I don't know if you filed a response to Ms. Smith's brief. If you did, I didn't have a chance to get that and review that.
No, I did not, Judge. Although it was short, I think I set forth the relevant facts in it. And B, Ms. Smith is aware of all the facts because she has the same police reports I do. She's not objecting to the majority of it. She's only objecting, as I understand it, to two of the other alleged victims. And I did file a subsequent notice because I missed another potential victim. And I don't think she's objecting to that either. That was
Your Honor,
that was just filed last week.
Can I just clarify for the record, just so I have a clear record for my client? And I talked to Mr. Rao about this on the phone. It's been difficult to communicate with him in the prison because he's not getting mail that I'm sending. But we spoke on the phone on Monday. That was the last I talked to him, and we are connected on JPay. So I filed, and there's many other acts, and there's multiple alleged victims in this case. We agree that many of those other acts are going to be admissible. And so I objected to the other acts evidence of 3 individuals specifically, and I am withdrawing the objections with respect to JB because Mr. Fenton gave me additional information and those would be admissible at trial. So the only objections we have now are to the 2 complainants, the TC complainant, which is the 3-year-old who said she was touched at 3 or something, along those lines. And then the allegation that's essentially like the sending inappropriate pictures, the allegation with a 16-year-old. And just because those 2 individuals, their circumstances are very different than all of the other evidence in the case, as I have in my brief. I just wanted to let the court know we're withdrawing the objection with respect to Jeremy.
Okay. All right.
And thank you, Mr. Fenton, for the additional information on him. That worked. That was helpful. Thank you.
Yeah, I had neglected to file that initially, and that was just an omission on my error, so.
Okay, and then you're also objecting to the hearsay testimony under
So
803A.
that's correct. So the case involving the 3-year-old is where the 803A testimony would come in. So if the court's not going to allow that 3-year-old situation, then the 803A issue is really moot. If the court is going to allow the 3-year-old, then I would ask that we be allowed to argue the 803A issue.
Okay. All right. Mr. Fenton, how did you want to proceed? I guess, my thought in reading through the brief by Ms. Smith and the notice by the prosecutor, I don't know that I have enough information based on what I have before me to make the determination about the admissibility, because while your brief, Ms. Smith, it addresses some of the specifics, and the notice addresses some of the specifics. I don't know that I have enough information. So I guess my question to the parties is, should we set this for some type of evidentiary hearing where we can take some proofs, or do the parties want to stipulate to having the court review the police reports, the statements related to the individuals that you are objecting to? I'm open to either of those things, but I don't think based on just the information that's contained within the filings at this point provides the court with enough to make the kind of determinations that Ms. Smith regarding her objections, the similarities and so forth. So I'm gonna throw that out to you guys.
Judge, my suggestion would be that we just make offer of proofs. That's how I've normally done it for 404B motions, as opposed to taking testimony or having you sift through police reports. Largely what I wrote in my notice and what Ms. Smith wrote in her objections, I think we agree upon the facts. And we can summarize them again for you here during arguments, and then just make arguments as to why we think that the other two should be admissible or not admissible. That would be my suggestion.
Your Honor, my suggestion is we do whatever is going to give the court enough information. So if the court, Mr. Fenton's notice was very short. So when I was responding to what I could glean from it. But if there are more specifics, I want to be able to respond to every specific. So if this court finds it needs more information, I would rather get more information, brief it the correct way, have a hearing, whatever we need to do to make sure the court's fully aware, because this is an important issue for this trial, obviously.
Right. Mr. Fenton, do you have an objection to the court reviewing police reports from, that are related only to the two witnesses that Ms. Smith's objecting to?
Not at all, but she indicated and I indicated exactly what they would say. I don't think it's going to be complicated. I think context is important for arguments. I agree that they're dissimilar in some ways, but they're similar in other ways. So I don't know that it's going to be that helpful for the court to just look at the 404B reports without having looked at all the other reports too. And I don't want to impose that burden on the court. I think it's something that we could easily agree on a set of facts as an offer of proof. Like I say, I think the main proofs or the main facts are set forth in both of our notices, and we can do it again here orally. But if you want to just look at those, that's fine. Again, I'm not sure that just looking at those without having all the other reports is going to be all that helpful to the court, but however the court wishes to proceed.
All right, here's what I'd like to do then. I'd like, you don't have an objection to me reviewing those reports, Ms. Smith?
No, I don't, but I also do agree with Mr. Fenton that without seeing the other reports to see, those are very similar and then the two are not. I think the court would have to see all the reports.
Well, this is what I'm thinking, and you guys tell me if you think that would satisfy your concerns. What I want to see are the statements that are made by these individuals that you're objecting to, Ms. Smith. And then once I know exactly, what their statements are and what their factual scenarios are, at least as they've been represented through the police reports, then set this for a hearing in 30 days, and then have the two of you simply do what Mr. Fenton is suggesting, which is provide that context to me through oral argument, and that way the two of you can address the important similarities or dissimilarities from all the other reports without the court having to go through them. You guys can highlight that for the court, but then I at least have, I've reviewed the statements of the individuals at issue where I can compare what you're telling me to what their statements are.
That sounds perfect. That does sound great.
All right, Mr. Fenton, are you okay with that procedure?
I'm more than okay with that. What I can do is, either way, either myself or Ms. Smith or even Detective Crane here can provide those to the court. And we were going to ask for another adjournment anyway in the status conference, because I've made a better offer than I've ever made before in an attempt to try to resolve the case short of trial. And I think Ms. Smith needs more time to talk to the defendant about it anyway.
I do, Your Honor, and I spoke to my client last on Monday, but the problem is, obviously now that he's in prison, I have way less access to him, and so I just wasn't able to get another appointment to talk to him before today. So we are asking for more time in terms of the status conference so that I can talk to Mr. Rao further and go over the new plea offer that was made Monday.
Okay. So let's do this. I'm going to set this for a hearing on the objections in about 30 days. I'm going to set aside a half an hour for that. And then we can address if parties want to, you know, depending on what the negotiations are. If we do have a plea agreement by that time, then we can always do that. If not, then we'll have the hearing. I'm gonna ask Mr. Fenton and Ms. Smith that the two of you just communicate off the record and stipulate to those whatever reports, and then just agree on who wants to submit them to the court. If you can just submit them to my office, to Jennifer at my office. And then I'll have a chance to review those before the next hearing, and then we'll go from there.
That's no problem. Will the court just go ahead and issue a date and send it to us? Okay.
Yeah. It'll
I,
be my next motion, full motion day here, so it'll be in early July.
do you happen to know, I have a 1 week trial scheduled in July. I just want to make sure I'm not gonna run into a conflict.
July 3rd is your Wednesday.
Yeah, it'll be on July 3rd.
Okay, July 3rd is great.
Okay.
Okay.
All right, Mr. Fenton, anything further from your side today?
Nothing, Judge, thank you.
Okay, thank you. That's all for today on this case.
Ms. Smith, I'll just indicate, I'm gonna scan what I think are the appropriate reports and email them to you, and if you approve of them, I'll forward them to the court.
Yeah, that sounds perfect. And then I'll be back in touch with you, Mr. Fenton, and I'll be back in touch with you, Mr. Rao. We'll go from there.
Okay.
Thank you.
Okay, thank you.
That concludes the court's morning docket. The court will be in recess until 1:30.
Appreciate it.